A full bench of 3 judges will deliver judgment today in President Cyril Ramaphosa's urgent application to halt former President Jacob Zuma from taking any further steps to his private prosecution bid against him. Now, the Gauteng High Court in Johannesburg heard arguments on Thursday from lawyers on behalf of the president, the former president and the National Prosecuting Authority on the matter. For more on what we can expect today, we are joined on the line, I think it's via Zoom, by legal analyst Mpumelelo Zikalala. Good to have you, Mpumelelo. Thanks so much for joining us here on the program.
Thank you very much for hosting me. Good morning to you, and also good morning to your viewers.
Let's just unpack this for those that haven't necessarily been following this in detail. What is happening? What happened on Thursday, and what is actually sitting before the courts?
On Thursday, arguments were made with regards to Part A of the application. Now, there are 2 parts. Part A deals with the agency, whether it is a matter of such agency that it should be heard on an urgent basis, it should jump the queue and be the first to be considered by the judges, and a judgment will then be issued. And then there's Part B. Part B deals with the merits of whether is a certificate that has been issued effective enough, for lack of a better word, or maybe a much more easier example, to ensure that the president can be able to be taken to court on a private prosecution basis. This way also the merits or the authenticities of the certificate will also be considered, and whether does it have enough powers to hold the president in front of the judges so that he's able to answer. So for today, the only judgment which is going to be issued with regard to the agency. Now, our courts are very clear when it comes to urgent applications. They say if you want to jump to the queue and be heard on an urgent basis, you must be able to prove that there's a right that you need to protect. You are going to suffer irreparable harm. There are no other alternative remedies or dispute resolution forums that you could have traversed before you got here. And on a balance of probabilities, certainly you may have, or you are going to win in the main trial if the matter were to move forward. So out of all the 4 that I've mentioned, only 2 are in the favor of the president, and there are only 2 which, to my personal analysis, I would say he wasn't able to satisfy. The first one is irreparable harm, because he wasn't able to show on the papers what irreparable harm is he going to suffer. The most stringent test is that it must be a matter of life and death. In this case, it's not. Whatever harm that he is going to suffer can always recover from it. Yes, there's brain suffering that may take place, but it's not irreparable. It can be repaired at some later point in time, if indeed it's vindicated. But the most important one is that there is an alternative dispute resolution forum in which can be able to cater for this. And there's a court which is going to sit as a criminal court, which is going to decide whether the certificate is authentic or not. In fact, the Criminal Procedure Act under Section 106 is the list, the title of, or the known title to prosecute as a defense that one can be able to raise. So the question would then be, Mr. President, why do you want to jump the queue in terms of your defenses when you have a proper forum in which you can raise all these defenses? Yeah. But another glaring point was this, Leanne. The NPA was not really included in this particular matter in sense of any attacks which were drawn towards them. Let's remember, they are the start of the instigators of this whole process. If you don't have the certificate which is not suspect-specific issued by the NPA, you wouldn't have the president running to court and saying, please defend my rights. So I was a bit worried as to why the president did not say to the NPA, please fix the blunders that you have made, or give me an assurance that indeed whatever which is being stated in the media statements is indeed true. We do not communicate through media statements when there are court matters. You deal with it with the processes that are there. So it's a bit worrying as to why is the NPA not really involved in this particular matter, and why are they leaving these 2 parties to this particular dispute when the source of that dispute is pertaining to the certificate that has been issued by the NPA.
Yeah, and I think this is the question that a lot of people are asking, and also feeling that the NPA honestly were not prepared in any way for what is actually what we're seeing unraveling in a court of law. And this is, this is the problem, is that, you again start seeing that South Africa is almost being run through the courts of laws. And now we're looking at the president and a former president going head to head in this court of law. So let's talk about this Part A, which is the urgency. So the court, as you have brilliantly put, will look at whether the elements of urgency, where it exists, mainly is there a right that must be protected. Will the applicant suffer irreparable harm if the order is not granted? Are there alternative solutions available to the applicant? And lastly, the probability of actually winning this matter.
Let's start with the 2. Now, when you say the applicant, there must be a distinction. Are we talking about the president, Mr. Ramaphosa, as the president? Are we talking about Mr. Ramaphosa as an individual? Now, in the papers that were submitted by the president, there seems to be no distinctions between the two in terms of saying, please look at me in a wholesome manner. Look at me in both capacities in terms of the things in which I'm going to be able to suffer at the end of the day. Now, regardless of how you look at it, at the end of the day, there is some type of harm which is going to be suffered, but it is not harm which is irreparable. People go to court on a daily basis, they're accused on a daily basis, and they're exonerated on a daily basis. Yes, it may be unfortunate that at the end of the day, people are simply going to say sorry to you for bringing you to court and you've won your actual case, but there are ways of repairing or putting you back in a position that you ought to have been had the litigation had not taken place. In this particular matter, when it comes to private prosecutions, they even request a deposit. I think it has already been paid. So if any harm is going to be suffered from a brand perspective, certainly you can be able to recover from it at the end of the day. Now, when you come to alternative disputes, that's where the backlog of the jurisdiction of the court is going to come in. You have a civil court, which the question the court would need to answer today, do they have powers to tell the criminal court what to do and what not to do, whether to adjudicate a certain matter or not to adjudicate a certain matter? Now, the manner in which the summons were issued is not in dispute. I stand to be corrected on that one. But if they are not in dispute, it means that the president has been called to court in a proper manner, and he needs to comply with the rules and be in attendance. And once he is in attendance, which is something which is afforded to by our legal system, he then has the opportunity to answer and be able to respond and defend himself on that basis. Now, you can't have a court telling another court, do not use the laws and powers in which are at your disposal in order to listen to a matter, just because the matter has been submitted to me as an urgent basis, which is why this assessment of alternative basis comes as a crucial point when assessing agency, because that means I'm not going to assess any matter because there are alternative remedies that are there. Why should I ball myself with something that is going to be adjudicated at a later stage? Now, the later stage that you are considering in this particular matter is that you can go to court and argue and say, the Criminal Procedure Act allows me under Section 106 to raise this defense. This is the defense that I'm raising, in addition to the defenses of saying that I don't have the power as a president to discipline misbehaving prosecutors. That's the prerogative of the National Director of Public Prosecution. If they fail there, they also have the Legal Practice Council, the ministers also there. So I, as the head of state, yes, they may be accountable to me ultimately, but I'm not involved in the day-to-day basis. And it's good because for it to be like that, because it ensures the independence of the NPA in doing their prosecutions.
Yeah. After just another point is that of the court jurisdiction. I mean, the matter will eventually be heard in a criminal court. So the question which, is being asked, and the court has the ultimate power to actually deal with this matter.
Definitely. Now, in this case, do we have the civil court which had the matter on last week, Friday, if I'm not mistaken, or do we have the court which is supposed to hear the matter on Thursday? So that's the backline in which the courts will have to deal with it at the end of the day. They're going to say, my presumption would be, yes, we have the doors of the court are open, we can listen to anyone. However, if there's another dispute resolution forum or a court which is supposed to hear the matter or has much better competency in terms of listening to what is there, let your dispute be dealt with in that particular court and not here. Now, if the court says that that's a detrimental blow to the bid or the application of the president, because that means that his application would have failed on urgency. Had the president filed an urgent application against the NPA and said to the NPA, fix your blunder in terms of the non-suspect specific non-prosecutor certificate, then the situation could have changed, which at the end of the day, it falls directly into the hands or the feet of the NPA in terms of saying, the certificate that you've issued for Alfred Billy Downer is clear. It said that the name of the suspect is Alfred Billy Downer, and the person is going to prosecute is Mr. Zuma. In this case, it is just a blanket certificate that is not name or suspect specific, therefore indirectly delegating all your powers to say, anyone who appears in that particular docket or affidavit which was submitted is game. They can be prosecuted by the certificate that has been received. You can't have that particular situation, because if you do that, you are not showing the court and us as members of the public that as the NPA, as the ultimate prosecutor of all crimes in South Africa, you have assessed individually the elements which are applicable to all the applicants or to all the individuals that have been named, and you are satisfied that you are not going to prosecute on that particular matter. And you're not going to even provide certain conditions which are going to apply in terms of the particular prosecution as empowered by Section 8 up until 18 of the Criminal Procedure Act. So on that basis, the certificate is what has caused this particular problem. The certificate is issued by the NPA, and the NPA is the only one that can be able to solve this issue.
So, okay. So, I mean, in other words, I mean, we should be, at the end of the day, this should be sitting in front of the NPA. I mean, to take it to courts, this is just taking it a step too far. And many saying, and particularly which we heard in the courts as well, saying that former President Jacob Zuma has ulterior motives, especially with the timing of all of it. And that's how some people are looking at it, and saying that if we see President Ramaphosa now before the courts, according to the ANC, he needs to step down or step aside while this is happening. So there is a lot playing out here. There really is. And this is an important judgment for the country and for the president that is going to happen at 9:30 this morning. So if I may, I mean, from when you saw the arguments that were both given last week from both sides, where do you think this is going?
I think on the basis of the agency, the court is going to say your matter is not urgent. Please go and attend court on that particular game. However, that's part A, by the way, dealing with agency. I don't think President Ramaphosa is going to be successful on that one. But on part B, when it comes to the merit, I think he is going to be successful because his defense is clear. He says, I'm the president. I'm not the one who's supposed to chastise misbehaving prosecutors. This is not my prerogative. It's not something in which I'm supposed to do. Please go and knock at the correct door. I think on that basis, and also attacking whether the certificate has been drafted in a proper manner, in a manner in which certificates are supposed to be issued, definitely favors on his side. His only mistake was launching this particular agent application and only directing to the former president, not really directing any instructions to the NPA or forcing them to act in a manner in which they can be able to resolve their mistake. So the mistake has been identified. It's just that the manner of fixing is not something which is going to bring about results in which the president will not go to court on Thursday.
So, I mean, this whole thing about noli prosecute, I don't know if I'm pronouncing it right. We all have to shine up our legal degrees that we don't have. So I'm trying my hardest here. So if we look at that, I mean, it basically certifies that Zuma relied upon for his summonses did not relate to him or a charge against him. So you're saying that the president is quite sort of, he will be more successful with regard to this?
Definitely on part B. But let's separate the two, the certificate. The certificate is supposed to be issued when the NPA says we are not going to prosecute. We've looked at the sequence of events, at the evidence before us. We do not think that you're going to come back with a conviction. Basically saying with the facts that we have, we're not going to come back with a guilty beyond reasonable doubt verdict. So you can go and prosecute on your own. Just make sure that you cover the cost and all the repercussions which are going to follow at a later stage. Yeah. Now, once that has been issued, it must have the name of the suspect as stated earlier. But when it comes to the president and the manner in which he's being accused, now, the president is accused of being an accomplice or an accomplice in not disciplining a prosecutor who ought to be prosecuted or disciplined by the National Director of Public Prosecutions. Now, on that basis, the president is going to say, but where do I feature in all of these particular processes? As the NPA is supposed to act independently, not being influenced by any of us at the end of the day, so that they're able to do their work without any fear or favor. So on that basis, I do not feature anywhere. Even the Legal Practice Council can then come in. So why I'm being held to court for being an accomplice in certain media or certain information which was allegedly leaked to the media, I do not know where I feature in all of this particular aspect. Even with the processes of the ANC constitution is very simple. It says the Integrity Commission will take the decision and make the particular recommendation. I do not see that particular Integrity Commission taking this advice and saying that the president must step aside, because they are going to look at the person who was prosecuting. If it was the NPA and not a private prosecution basis, maybe they would have been convinced otherwise. But if they see that it is a private prosecution, they're going to put their political glasses on and then say, let's look at who's the prosecutor behind this, and then we can check whether there are ulterior motives. And that's where the argument of the president can then come in.
All right, we've got to leave it there for this morning, but thank you. 9:30, that's when we should be hearing the judgment in all of this, but the fantastic legal analysis that we've just received there is from Mpumelelo Zikalala, speaking to us about that judgment, the expected judgment in President Cyril Ramaphosa's urgent application to halt former President Jacob Zuma from taking any further steps to his private prosecution bid.